Hello, my name is Michael Tesoro and I've prepared this case note on the recent case of ACCC and IVF Finance. Just a bit of background about myself. I work as a competition and consumer lawyer for my own practice, Tesoro Legal Consulting. I've been doing that for about 13 years and I've helped a few clients with mergers matters during that time. However, probably more relevantly, prior to setting up my own practice, I worked at the ACCC in a number of roles, and relevantly to this presentation, I worked as the director of the Sydney Mergers and Asset Sales branch for a number of years, and in that role I conducted merger assessments. I also prepared interim injunction applications with the lawyers that we used on the cases to try and prevent mergers from proceeding. The most relevant one is the work I did on the Waddell-Taubman's merger, where we prepared an interim injunction application. So I gained some insights into how to prepare these types of applications, which I wanted to share with you. I also prepared a few of these types of applications in relation to the maritime union cases, which I ran for the ACCC when I worked there. Okay, just the outline of the presentation. I thought I'd summarise the case quickly and then get into the federal court decision of most relevance, which is Justice O'Brien's second decision or decision in the case, and then end up with some commentary on the case and some learnings. Now, the summary of the case, IVF Finance, which was a subsidiary of Virtus Health, entered into a share sale agreement with Helios to buy the Adora fertility business. And the Adora fertility business consisted of 4 fertility clinics located in Brisbane, Sydney, Melbourne and Perth, and there were also 3 day hospitals that were included in the transaction. So that was the transaction, but the main concern that the ACCC had was with the purchase of 2 of the 4 fertility clinics in Brisbane and Melbourne. Now the chronology is interesting, so I'll just run through quickly. The first step was Helios seeking buyers for the Adora business back in May 2021, and Virtus submitted an indicative bid in July and were accepted as the preferred bidder at the end of July. The share sale agreement was executed in August, and then the transaction publicly announced. And then on the 30th of August 2021, Virtus advised the ACCC of the acquisition. Now, there's a lot of correspondence from August through to October between the ACCC and the legal advisors for Virtus, but relevantly on the 8th of October, Virtus informed the ACCC that they intended to complete the acquisition on 15th of October. The ACCC responded by asking for undertakings that it not be completed, which were not given by Virtus. So as a result, the ACCC commenced proceedings for an interim injunction on the 13th of October, which was granted on the 14th of October, which effectively stopped the transaction from going ahead on the 15th of October. And then there was a more involved hearing before Justice O'Brien on the days following that, and on the 25th of October, the court granted an interloctory injunction preventing the merger from proceeding until a final hearing in 2022. However, a more recent development was that on the 17th December 2021, Virtus announced that it decided to end the acquisition of Adora. Now, even though Virtus has decided not to proceed with the acquisition, I think there's quite a lot of interesting issues and interesting law that came out of Justice O'Brien's decision, which would be of benefit to understand. So that's what I'll seek to do in this presentation. So the first issue is to understand what legal tests the court has to apply when they're looking at an interlocutory injunction. And as you can see, there are 2 limbs. The first limb is that the applicant, which in this case is the ACCC, has to establish a prima facie case, which is a pretty low standard of proof. The second limb is that the balance of convenience favours the grant of the injunction sought. Now, when the court's looking at the first issue, it has to be satisfied that the applicant has established there's a sufficient likelihood that they're going to be successful in their final hearing. So it's a low standard, but they have to prove to the court that they've got a sufficient likelihood of success and that the status quo needs to be preserved. Then once that limb has been satisfied, the court has to look at the strengths and weaknesses of the case, but more importantly, it has to look at the detriment that allowing the merger would cause to the public interest in maintaining effective competition in the market, and balance that up with the likely inconvenience and injury that preventing the merger would cause to the merger parties. So they have to balance up the public interest in having competitive markets with the damage that will occur to the merger parties if an injunction is granted. So ACCC made a number of submissions on prima facie case. Firstly, that there'd be a significant increase in the level of concentration in the two relevant markets, Brisbane and Melbourne. It argued two alternative markets. They argued there was a low-cost market, and which focused obviously primarily on what Adora was doing, which is a low-cost provider of IVF services, but also a larger fertility services market. And they argued that in both of those markets, the level of concentration in Brisbane and Melbourne would go up significantly. They also argued that there was substantial competition between Virtus and Adora, both in the low-cost market and also in the fertility services market, which would be lost if the merger proceeded. And thirdly, that there'd be a significant reduction in choice for patients who looked at the two competitors, particularly in Melbourne and Brisbane, as suppliers of IVF services. IVF submitted that the prima facie case had not been made out by the ACCC, and they focused in on three primary issues. Firstly, that the market had been wrongly characterised by the ACCC. It wasn't a fertility clinic market, rather there was a market for doctors who provided fertility services, and they were independent contractors effectively who competed against each other. They also argued that treatment cycles was not the right way to measure market concentration, which is the way the ACCC had measured it. And finally, that there was a history of new entry into these markets by small players, and that the fact that so many new players have been able to come into the market quite quickly indicated that barriers to entry were low. The ACCC made submissions on balance of convenience. Clearly, it had to argue that substantial and irreversible harm would be caused primarily in the low-cost market, but also in the broader market. They also argued that some undertakings which the parties had proposed would not overcome the harmful competitive effects. There was two undertakings proposed, a short version and a long version, and they argued that those undertakings were inadequate. Also, a divestiture order after the event would not be an effective remedy. It wouldn't be able to unscramble the egg. And finally, they argued that neither Virtus or Adora was likely to suffer any significant prejudice if the merger was injuncted. IVF submission in response were that there were significant risks to the business if the merger was injuncted, the primary risk being that specialists and staff employed by Adora could just leave and go and set up their own practice or join Virtus's competitors. They also argued that there was a risk that Adora business may diminish or fail. This was largely due to the fact that Helios was involved in other types of activities, and the fertility business was very much a non-core part of the business. So the argument was that Helios would not continue supporting the Adora business going forward. Further, that Adora would face immediate and significant clinical and other risks, and they made some reference here to the COVID risks and related sort of risks. And finally, that IVF would suffer significant financial and loss of bargain risk arising from the share sale agreement. So they argued there was a lot of detriment that would be impacting both Virtus and Adora if the merger was injuncted. Now, there was a lot of evidence filed in an interloctory injunction case, and the ACCC filed a lawyer affidavit with lots of internal documents, as well as two economist reports, one by Dr. Williams and one by Dr. King. Dr. Williams's report was very much on the prima facie case issue, whereas Dr. King was focusing more on the balance of convenience and the effectiveness of the undertaking. IVF filed a few affidavits from senior executives, the medical director, and also obtained an economist report from Dr. Houston. Now, looking at all the evidence, the judge was not very impressed by some of the evidence which was filed by IVF. For example, they filed management evidence trying to explain away some of the internal minutes that had been put into evidence. And these minutes showed quite clearly that there was a concern in Virtus that if it did not acquire Adora and the business was acquired by a competitor, Virtus would face increased competitive pressure. So it's difficult when your lay witness is trying to provide evidence which goes against your internal minutes, which were drafted many months before. The judge was also unimpressed with some of the commercial concerns raised by Virtus, which he described as being somewhat disingenuous. Also, the argument that there was a doctor market as opposed to a fertility clinic market was rejected by the judge because he just didn't believe that the evidence supported the existence of that market. In their internal documents, they didn't describe the market in those terms. And finally, the economists sought to challenge the existence of the low-cost market and submitted that it didn't actually exist. However, again, the evidence that had been filed clearly established there was a low-cost market. I guess it's fair to say that the ACCC didn't have it all its own way. The ACCC did form the view that, the court accepted the ACCC submissions that concentration ratios were going to go up significantly, that Adora was a vigorous and effective competitor, but it didn't accept the evidence that there was high barriers to entry. It said that the evidence was equivocal on that point, as there'd been a lot of new entry into markets over the recent years. So the judge concluded that the evidence on that point was not strong. The other thing is the evidence purportedly put on by Dr. King was effectively rejected as evidence. As people may know, Dr. King is a former commissioner for the ACCC, and the evidence he put on didn't satisfy the judge as being independent expert evidence, and therefore he didn't accept it on that basis. Rather, he accepted Dr. King's evidence as submissions on behalf of the ACCC. Now, the decision on the prima facie case was that the ACCC had established that there was a risk to competition if the merger was allowed to proceed, that, as I said before, market concentration ratios were very high post-acquisition, that Adora was a vigorous and effective competitor, that there was a high degree of competition between Virtus and Adora, but the barriers to entry were not, the evidence on barriers to entry was not strong. So the ACCC was successful on most of the arguments that it raised. However, there was still the balance of convenience issue to address, and the key consideration there was, would the undertaking that was proposed by the parties be sufficient to keep the business separate while the trial was approaching? So here the judge did accept the submissions made by Dr. King on the undertaking not being a sufficient remedy to keep the businesses separate. And he identified 5 particular issues that caused him concern. Firstly, he saw a number of carve-outs in the undertaking which he thought were very broad and created, suggested significant integration between the businesses during the period of the undertaking. Also, he thought that there wasn't clear accountability for the independent manager as to who that person would be reporting to. He thought that the reference to Virtus having some role in day-to-day competitive operations and decision-making was vague, and it wasn't clear what that would include and not include. Also, he found it somewhat vague and lacking in practical content that the undertaking would ensure that Adora remained a viable and effective and independent business. So he couldn't see how can that be guaranteed. And finally, he wasn't sure how the undertaking would guarantee that competitively sensitive information wasn't shared between the two companies. So on those bases, he concluded that the undertaking would not be a sufficient remedy to assist the merger parties in the balance of convenience arguments. So he concluded that the balance of convenience favoured the granting of an interloctory injunction. He said there's a substantial public interest in preventing uncompetitive or anti-competitive mergers, and the undertakings were an imperfect solution. And further, that he gave less weight to some of the factors of risk that were identified by the merger parties, primarily because they had brought the problems on themselves. He mentions this a number of times, that the risks are actually self-inflicted by the decision of the merger parties not to seek ACCC approval of the transaction on a formal basis. So he ultimately concluded that there was prima facie case had been established, that the acquisition would be likely to have the effect of substantially lessened competition, and the balance of convenience favoured the granting of the injunction. Now, just some final commentary on it. The balance of convenience evidence was somewhat puzzling because effectively that was evidence put on by Dr. King, whose evidence wasn't accepted. It was accepted by the court as submissions. So in the absence of evidence on that point, you have to ask yourself how the court decided the balance of convenience favoured the ACCC. Now, it also seems to me that the idea of using an economist to provide balance of convenience evidence is not ideal. I know that when I worked on the Waddell-Taubman's interloctory injunction, we used some accountants who were very specialised in corporate reconstruction work, who knew how to run businesses and had practical experience running businesses, and all the ways that businesses would be merged together and very hard to undo. So we use those type of experts, and I think that's the better way of going when you're trying to put on balance of convenience evidence. I'm also not too sure the self-inflicted argument was an appropriate argument to put so much weight on. Justice O'Brien mentions this a number of times in his decision, and he says, you know, for example, however, to the extent inconvenience or injury arises, it is largely self-inflicted and was avoidable, and therefore he gave it less weight. And he reiterated that the uncertainty was largely self-inflicted. I'm not too sure that's a relevant consideration, because ultimately it's a balancing exercise between the detriment to the public compared to the detriment to the parties. And I'm not too sure that the judge should be importing ideas of parties having brought the problem upon themselves. Really, that seems to me to be an extraneous consideration. The final observation is the undertakings, and the point that I was surprised wasn't made by the merger parties is that the undertakings appear to be pretty well modelled on the types of undertakings that the ACCC routinely accepts from merger parties in a divestiture situation. For example, I was the independent auditor of the Bingo divestiture of the Banks Meadow waste facility, and there was an elaborate undertaking there whereby an independent manager was appointed to run the business. My role was to oversee the performance of that role, and the undertaking's profit in this particular case seemed to be almost identical to the ones that the ACCC accepts in those divestiture situations. So it seems somewhat strange that the ACCC was successful in arguing that these undertakings would not be effective when they were very similar to undertakings which the ACCC had accepted in quite similar context elsewhere. So I think there's quite a lot of interesting aspects in this case which will be relevant for parties engaging in mergers. I think the idea of not allowing the ACCC to have a look at your merger and trying to call their bluff and expecting them to maybe fail in preparing an interlocutory injunction application is a mistake. The ACCC is quite good at this. They might have been lucky here in a few respects, but probably the main tragedy of this particular case is that given the findings on a preliminary basis in relation to barriers to entry, there's a strong argument this merger was not anti-competitive. If you went on barriers to entry in a merger, you're likely to get it through. So it seems to me that the parties that allowed the ACCC to look at the merger, they might have been successful in proving that the merger was not anti-competitive. So that's all I had. If you have any questions about this presentation, feel free to give me a call or drop me an email. Bye-bye.